Hey everyone, Trip Watson here from the Watson firm. One of the big questions I always get is what types of contracts that businesses need. And a lot of businesses don't understand that they need to have some contracts that are in writing. And this follows what's called the statute of frauds. Basically, these are rules that set out which contracts must be in writing. And there's an easy way to remember this. There's an acronym called MYLEGS, MYLEGS. And basically, this breaks down the different types of agreements that have to be in writing. First, marriage contracts. Not very common in a business context, but if you're going to agree to marry somebody, you got to have it in writing. The second one is years. Why? If it's going to be more than 1 year before performance can be performed, it's got to be in writing. So if there's any possibility whatsoever that the contract can be completed in less than a year, then it doesn't have to be in writing. However, if there's no way that it can be done and finished and completed in 1 year, it's got to be in writing. Next, L. Anything that needs to be transferred in land, any interest in land, any encumbrance of land, any transfer of land, any mortgage on land has to be in writing. E, executors. Executors that are trying to close out an estate that might be willing to settle the estate personally in order to make sure that everything gets handled. And that's not allowed unless that's in writing. Very rare, but it does pop up. G, the sale of goods. This is one of the biggest changes that we've seen in the UCC has made, that the Uniform Commercial Code has made to the statute of frauds. The big change here is that if you buy goods that are over $500, then that needs to be in writing. Otherwise, if there's services or if it's less than $500, it doesn't necessarily have to be in writing in order to be enforceable. Next is S, surety ships. If you ever agree to take out or be personally liable for any type of responsibility, financial or otherwise, for somebody else, that's got to be in writing. So if you co-sign on something or if you sign a personal guarantee, that has to be in writing. Now, there's been some changes that take you outside of the MYLEGS approach. So, for instance, Alabama has passed a law now that we recognize non-compete agreements in the state. However, those agreements have to be in writing. There's also some other provisions that don't necessarily have to be in writing anymore that used to have to be. So for instance, sometimes short-term residential leases don't have to necessarily be in writing. So it's important to know what you're getting into. So if you do have a specific question, consult with an attorney to figure out whether or not you need to have it in writing. And then once you're good to go, make sure that everybody gets signed on the dotted line and make sure that they're on the same page. Again, this is Trip Watson from the Watson firm. Y'all have a good day.